power, law, and double standards, why the world is sliding toward a dangerous precedent. Part 2. International Law, U.S. Exceptionalism, and the Collapse of Legal Restraint. International law, clear on paper, fragile in practice. Modern international law is not vague. It is explicit. Under the UN Charter, the use of force is legal only in 2 circumstances: self-defense against an armed attack, or authorization by the UN Security Council. Regime change, punishment, deterrence, or sending a message are not legal grounds for military action. This framework was deliberately designed after World War II to prevent powerful states from acting as global enforcers based on subjective interests. When a state bypasses this framework, it is not merely violating a rule, it is undermining the system that prevents global anarchy. The ICC, jurisdiction, limits, and political pressure. The International Criminal Court, ICC, was created to prosecute individuals, not states, when crimes of genocide, crimes against humanity, or war crimes occur. Its authority depends on state membership, UN Security Council referral, or crimes committed on the territory of a member state. The United States is not a party to the ICC and has historically resisted its authority, fearing exposure of U.S. officials and soldiers. Yet Washington frequently invokes international justice rhetorically when it aligns with its strategic interests. This creates a structural contradiction. The U.S. demands accountability from others, while shielding itself and its allies from the same mechanisms. This is not skepticism. It is selective legitimacy. Netanyahu versus Maduro. The double standard made visible. The contrast is stark. Benjamin Netanyahu faces an ICC arrest warrant for alleged international crimes. The U.S. publicly challenges the ICC's authority in this case. Meanwhile, Nicolas Maduro faces no ICC warrant. Yet the U.S. pursues unilateral coercion, sanctions, and alleged military action. The message to the world is devastatingly clear. Judicial process applies when convenient. Force applies when preferred. This destroys the credibility of international justice as a neutral system. U.S. exceptionalism, the unwritten doctrine. At the heart of this pattern lies American exceptionalism, the belief that the U.S. operates under a different moral and legal standard because it sees itself as a global stabilizer. This doctrine is never formally codified, but it governs behavior. U.S. actions are framed as enforcement, not aggression. Violations are described as necessary, not illegal. Accountability is portrayed as a threat, not a safeguard. Exceptionalism transforms law into advice, not obligation. Sanctions as collective punishment. Sanctions are often described as a peaceful alternative to war. In reality, comprehensive sanctions function as economic sieges. In Venezuela, sanctions have contributed to currency collapse, shortages of medicine and food, mass migration, institutional decay. International humanitarian law prohibits collective punishment. Yet sanctions regimes rarely face legal scrutiny, despite overwhelming civilian harm. Once again, legality yields to leverage. The normalization of legal gray zones. Modern interventions increasingly rely on ambiguous justifications. Counter-narcotics operations. Counterterrorism. Protection of democracy. Humanitarian intervention without UN approval. These gray zones are not accidental. They are engineered to bypass legal thresholds while maintaining plausible deniability. When gray zones become normal, law becomes optional. Part 3. The global consequences. From precedent to peril. If the rules are optional, power decides. International law survives not because it is enforced equally, but because powerful states restrain themselves. Once that restraint disappears, every power becomes its own judge. This is already happening. Russia cites Western interventions to justify Ukraine. China references sovereignty narratives selectively. Regional powers expand influence through force. The erosion is cumulative. The UN's silence is not neutral. When the UN fails to act decisively, it does not remain neutral, it becomes irrelevant. Veto paralysis has transformed the Security Council from a guardian of peace into a stage for geopolitical theater. This vacuum invites unilateralism. World War III. Not a scenario, a trajectory. Global wars do not begin with declarations. They begin with normalized violations, escalatory precedents, and mutual distrust. Today's world features nuclear-armed rivals, regional proxy conflicts, collapsing legal norms, hyper-militarized rhetoric. This is not stability. It is managed instability, drifting toward collision. Democracy cannot be delivered by cruise missiles. Democracy imposed by force is not democracy. It lacks consent, legitimacy, and sustainability. Afghanistan and Iraq proved this conclusively. Democracy grows through institutions, culture, accountability, and time, not occupation, sanctions, or assassinations. Sovereignty is not an excuse. It is a principle. Respecting sovereignty does not mean endorsing repression. It means recognizing that change must follow law, not power. Without sovereignty, there is no equality. Without equality, there is no order. Without order, there is only force. Final conclusion, law or chaos. The world stands at a crossroads. One path leads to restored multilateralism, strengthened international law, and genuine accountability for all, friends and foes alike. The other leads to a hierarchy of force, where might defines right, legality is selective, and war becomes a policy tool. The choice is not ideological. It is existential. If international law is abandoned by those who wrote it, no one will be protected by it. And if power replaces principle, then global conflict is no longer a risk. It is an inevitability. The question is no longer who is right. The question is how much damage will be done before restraint returns.